So next up is Bill Walker, who for nearly 20 years has been an Article 5 convention advocate. He helped co-found the first national nonpartisan group, Friends of the Article 5 Convention, which is dedicated to causing Congress to call a convention. He's filed 2 federal lawsuits regarding peremptory obligation of Congress to call a convention, and he's also gathered into a single photographic collection taken from official government records for the first time in U.S. history, the actual texts of over 700 applications from 49 states submitted to Congress for a convention. So, Bill, please.
Hi. No doubt many here have studied the official public record of an Article 5 convention, including all pertinent historic documentation, congressional proceedings, judicial rulings, and current events. Originally, I was to prepare a speech for this conference discussing these aspects. However, scheduling circumstances reduced it to this brief summary. For those interested in more details regarding these remarks, I'm leaving copies of the speech at the table. You can also visit our website at www.foavc.org to read this information. FOAVC is different from all other groups at this conference. We are nonpartisan. We have no amendment agenda. Our sole purpose is to cause a convention call. We have the only record of successful accomplishments regarding a convention call. Because of federal lawsuits, the government acknowledged for the first time in history the terms and conditions of a convention call. The Congressional Research Service has agreed to change its authoritative book on the interpretation of the Constitution to reflect corrections submitted by FOAVC. Thus, while others postulate unproved theories of same subject, fiduciary control of a convention, and so forth, we have achieved actual, real results based solely on the public record. As to current events, I'm sure all are aware that Mr. John Guise of Georgia, who is not a member of FOAVC, filed a criminal complaint in July with the Department of Justice against all members of Congress for the violation of oath of office for refusal to call a convention based exclusively on FOAVC information. After review by the FBI and the Georgia U.S. Attorney for frivolousness and substantiality, the complaint was forwarded to Washington, D.C. for disposition. This event marks the end of this issue. It will be officially resolved within a few weeks. Either the government will prosecute congressional members for violation of oath of office for failing to call a convention when mandated by the Constitution, meaning ultimately there will be a convention call, or it will determine members are not required to obey the Constitution, thus officially nullifying Article 5, the Supremacy Clause, and the Oath of Office Clause of the Constitution. So what do we know about the convention from the public record? We know the basis of a convention call is a simple numeric count of applying states with no terms or condition. This, of course, is based on Hawk v. Smith, 1920, and United States v. Sprague, 1931, where the court ruled states operate under the federal Constitution when engaged in the amendment process, cannot alter that process, and that there are no rules of construction, interpolation, or addition permitted in Article 5. In other words, unless textually expressed in Article 5, any theory such as rescission of applications, same subject, identical application language, fiduciary control, and so forth are unconstitutional. We know, as the President cannot participate in the amendatory process as specified in Hollingsworth v. Virginia, 1798, and Congress is forbidden by the necessary and proper clause that there is no federal legislative control of the convention. We know the public record proves 49 states have submitted over 700 applications for a convention call, first reaching the required two-thirds mark in 1908. The applications can be read at our website. We know the call is peremptory. Congress cannot legally refuse to call. Thus, we know a convention call is mandated now, not sometime in the future. As Congress has refused to call, we know further political efforts to acquire new applications imply Congress has veto power over this overwhelming number of applications, meaning Congress can veto new applications as well. Therefore, we know it is a waste of political capital to seek new state applications. The issue is Congress's refusal to call, not the failure of the states to apply. We know, based on Supreme Court decisions regarding the well-settled principle of the 14th Amendment's Equal Protection Clause, that as Congress and a convention are identical as to constitutional authority, effect, limit, and exclusiveness, they and the citizens they represent form a legal class, meaning equal treatment under the law. As we know, this resolves all operational questions, including terms and conditions of delegates' election, such as number of delegates, term of office, representation area, qualifications for office, election laws, voting ratio for proposed amendment passage, powers and limitations of office, loyalty issues, speech and debate immunities, and the manner of vote at the convention itself, as they are identical to Congress. We know Article 5 mandates Congress decide the time and location of the convention. Given the exorbitant cost of a physical convention and the political and economic advantages of a virtual convention, Congress is likely to affect this alternative as it cannot finance the convention. As the convention only has amendment proposal power and thus no means of income, we know delegates will be unpaid volunteers. We know this limitation also means election campaigns will be entirely issue-orientated. We know the agenda of the convention, as the states have already addressed nearly all of today's political issues with petitions to the convention for proposed amendments submitted within their applications for a convention call. We know the states can politically control the convention agenda in real time, but not by means of fiduciary principles, as some have asserted. We know there will be no runaway convention, as federal criminal law prohibits this. We know the convention will be entirely public. We know most dangerous convention is a single-subject convention with a predetermined political outcome. This kind of convention means exclusion of all political opposition and offers no reason for citizen participation of all issues are predetermined, thus excluding debate and vote. Such a convention violates the Speech and Debate Clause as well as Article 5 and therefore is unconstitutional. In sum, we know a convention is just like Congress with all significant aspects. Thus, there is no real obstacle to holding a convention. What about the question before this panel? The actual question, of course, is not political support of a convention, but whether to politically support giving the government official veto authority of the Constitution. As the DOJ will officially resolve this question shortly, there really is nothing to decide. If the government prosecutes for this documented violation of oath of office, public confrontations with members of Congress of their assumed right of veto are in order. Such confrontations will bring about a convention call. If not, it will not matter, as it will be official government policy. Congress and the government can veto the Constitution as they please. Thank you.